Good evening, Mr. Rucker, fellow students. Today I would like to speak to you about the First Amendment freedom of speech. Firstly, what is the First Amendment? Well, the First Amendment states that the Congress shall make no law respecting an established religion or prohibiting free exercise thereof, or abridging the freedom of speech, or the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. There has been much contention regarding this amendment, and thus matters regarding its specifics have been repeatedly brought to the Supreme Court. Today, I wish to bring up two such cases that question the extent to which a person may use the First Amendment to protest the government's actions, so that we may analyze them more closely. The first such case that I wish to bring to your attention is the case of Schenck versus the United States. During World War I, Charles Schenck, a general secretary of the U.S. Socialist Party living in Philadelphia, distributed leaflets declaring that the draft violated the 13th Amendment that prohibited involuntary servitude. The leaflets urged the public to disobey the draft through peaceful action. Schenck was charged with conspiracy to violate the Espionage Act of 1917 by attempting to cause insubordination in the law or in the military and obstruct recruitment. Schenck was convicted of violating this law and appealed to the Supreme Court, saying that his conviction violated the First Amendment. This led to the court, headed by Chief Justice Edward Douglas White, to ask the question, did Schenck's conviction under the Espionage Act for criticizing the draft violate his First Amendment right to freedom of speech? This case was argued January 9th and 10th of 1919. On March 3rd of 1919, in a unanimous opinion, the court held that Schenck's criminal conviction was constitutional. The court held the circumstances of wartime allow for a greater restriction on free speech than would be allowed during peacetime. This majority opinion was written by Oliver Wendell Holmes Jr., and due to the unanimity of the court, there were no opposing opinions at the time. This would change, however, sometime into the future when Holmes wrote a dissenting opinion to his majority opinion on the case. In subsequent cases, Holmes would dissent, reiterating that his view that expressions of honest opinion were entitled to near absolute protection, but that expressions made with the specific intent to cause criminal harm or that threatened clear and present danger of such harm could be punished. This case is vital as it led the Supreme Court to inventing the famous clear and present danger test to determine when a state could constitutionally limit an individual's free speech rights under the First Amendment. Sometime later, on March 21st of 1989, another case would once again come to the floor of the Supreme Court, and this was the case of Texas v. Johnson. In front of the Dallas City Hall, Gregory Lee Johnson burned an American flag to protest against the Reagan administration policies. He was tried and convicted under a Texas law that outlawed flag desecration. He was sentenced to 1 year in jail and assessed a $2,000 fine. Johnson appealed to this conviction to the Fifth Court of Appeals of Texas, but was again found criminally liable. He then appealed to the Texas Court of Criminal Appeals, which overruled his conviction, finding that Johnson's First Amendment rights had been violated. The state of Texas then filed a request to the Supreme Court asking for them to review the case. Because of this, the Chief Justice William Rehnquist was forced to pose the question, is the desecration of an American flag by burning or otherwise a form of speech that is protected under the First Amendment? During the oral arguments on March 21st, the state of Texas defended its statute on two grounds. First, states had a compelling interest in preserving a venerated national symbol, and second, the state had a compelling interest in preventing breaches of peace. June 21st, 1989, the court had come to its decision. Ruling in a 5-4 decision, the court held that Johnson burning the flag was a protected expression under the First Amendment. The court found that Johnson's actions fell into the category of expressive conduct that had distinctively political nature. William J. Brennan Jr. was the author of the majority opinion, which believed that the court's long-held recognition of the First Amendment to the United States Constitution protects non-speech acts as symbolic speech, writing that the First Amendment's protection on speech does not end at the spoken word or written word. Justice Kennedy filed a concurring opinion with Brennan's majority. In it, Kennedy acknowledged the potentially unpopular nature of the holding, but affirmed that the role of the Supreme Court is to uphold the integrity of the Constitution, even if sometimes we must make the decisions we do not like. The dissent was written by Chief Justice William Rehnquist, which stated that the unique position of the flag justifies a governmental prohibition against flag burning in the ways respondent Johnson did here. Citing the importance of the flag in history, he wrote that burning a symbol of national unification was distinctly separate from other political demonstrations where the freedom of speech might protect protesters. This case was important because it reaffirmed the fact that officials don't have the authority to designate symbols to be used to communicate only limited sets of messages, noting that if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society deems the idea offensive or disagreeable. These two court cases share the primary theme of the use of the First Amendment regarding actions other than speech or writing. The comparison of these two cases can also be used to demonstrate the changes in what may be regarded as legal free speech. Because the second case of Johnson v. Texas occurred later than Schenck v. U.S., it was given the benefit of having many similar past cases to pull from in their ruling. Because of this, they succeeded where Schenck did not. These two cases were picked to clearly demonstrate the development of the First Amendment between these two time periods. This evolution has allowed for a large increase in free speech through symbols and activism that would have not been legal in the early days of the Constitution. This is a great gain for the people, allowing us to increase our influence without restriction as a society of everyday citizens. Well, folks, that's all. Thank you for coming to my speech, and I hope to see you at my next gathering. It will be in the park by the swing set over there. You know where there's like 70 of you here. You got it. And Mr. Rucker, thank you for watching.